So our audience is,
Ah. We have I don't see question, Joy.
She's not here yet.
Yeah, so we have to wait for correction on. It's mostly,
intros.
yeah, closed, intimate circle of us, but,
Is here.
yes. We will, get things started and go published in just a moment. And who's not here? I see Larry,
Sorry, it's not here. That's it. No.
Okay. Good evening, everyone, and welcome to the Newburyport Zoning Board of Appeals. This is our special hearing published for the evening of December 15th, 2025, a continuation of the ongoing 40B comprehensive permit for comp 25-1. Is it 45 story? 45 Story Avenue. My name is Rob Champetti. I have the privilege of serving as chair. I know that this is an intimate room, so for anyone listening online, and it seems like there's only a few, I'll take a moment and just go through the quick preliminaries. Introducing the board, establishing our quorum, establishing the 5 voting members that will continue in the extension of this process. This is a continuation, having closed the public hearing of the 40B 45 Story Avenue application. The project known conveniently, I think, and descriptively as the Kmart 40B project. We've closed the public hearing and are about to enter deliberations before the board. Before we begin, I will call the roll and we'll get things going with introductions. So to my immediate left, I have Mr. Ken Swanton, our vice chair. To his left, Mr. Stephen Delisle, member. To his left, Mr. Gregory Bennett, member. To his left, Mr. Jared Eigerman, member. And to his left, Miss Caitlin Sullivan, our city planner. To my immediate right, I have Gareth Orsman, who is our city solicitor with Pierce Atwood. And to my far left, we have our planning director, Mr. Andy Portman. So again, my name is Rob Champetti. We also have Miss Gretchen Joy, who is by the door taking minutes and recording all of the details of this evening for purposes of posterity. I will call the roll and we'll establish a quorum. We'll get started with our business this evening. So calling the roll of the Newburyport Zoning Board of Appeals special meeting scheduled for December 15th, 2025. Mr. Stephen Delisle.
Here.
Mr. Ken Swanton.
Here.
Mr. Gregory Bennett.
Here.
Mr. Larry Ginton. Is recused. Mr. Jared Eigerman.
Here.
And Rob Champetti, I'm here. That's 5, 1, 2, 3, 4, 5, and the 5 present. That is a legal quorum. The 5 voting members will be myself, Mr. Delisle, Mr. Swanton, Mr. Bennett, and Mr. Eigerman. So with that, we will pick up from where we left off at our last hearing last week. In opening for the first time the deliberations portion of the project known as the comprehensive permit at 45 Story Avenue, aka 40B Kmart Port Plaza. With that, we will open deliberations. And so again, we are deliberating with the benefit of what has been published for the public benefit. Our city solicitors comprehensive permit memorandum, as well as some of the condition details that have all been made available to the public when last we met. So all of anything that's before us with respect to what the city solicitor, Attorney Orsman and Pierce Atwood have provided us has now been made for at least a week, part of the public record. So we are working from that as a sort of an advisory standpoint. As a board, so does anyone wish to begin? And my thinking here is that from an organizational structure, we should deliberate beginning at the beginning. So anyone who wishes to sort of go from the subject matter verticals of the topics that we dealt with this material from the very beginning. We dealt with traffic and parking, we dealt with engineering, we dealt with geotech, hydrotech, and site engineering, and we dealt with architectural. So any of those topics are fair game to begin. We don't have to go in any specific order, but we do need to specifically deal with each of them separately, I think. So anyone who wishes on the board who wishes to get started with deliberations, we can open a topic, a subject matter topic, and then deal with that for purposes of deliberations. And I think that's the best way to approach the work of what we have yet to do. Anyone wish to add to that? I certainly don't want to bully pulpit my way through this, but that's what I presume to be the best approach. Any of my colleagues wish to offer any alternative view or additional information, please feel free. Okay. Mr. Bennett, you look like a man about to make a.
Well,
about speak.
there are a number of waivers that are requested here, and I'm not sure how we're going to deal with those.
Why don't we deal with waivers as a topic?
It strikes me that perhaps we should, I'll suggest that we may want to go through the waivers individually and discuss them.
So
We haven't discussed those at the hearing in any major way, except they were tangential or significantly a part of our discussions about the major silos. But there are some, 20 waivers or something, there are some significant numbers, so.
may I suggest then that we deal with waivers as its own silo subject matter? Before we get into the other subject matters I mentioned, we deal with, perhaps the most sort of acute element of this, which are the specific requests to depart from the statute. And so we will call that the first order of business in terms of topical deliberation, and we'll call it topical deliberation in connection with waivers requested by the applicant. And we can unpack that until we're done unpacking it, I suspect. Mr. Bennett,
Yeah, that certainly is an excellent approach, yes, Mr. Chair. I guess that begs the question, who's going to lead us through the waivers? Well, Stephen has them in front.
I do have that.
Or
Yeah.
perhaps Gareth might want to do that.
Well, why don't we start with let's do this, if I might, and forgive me the indulgence for a moment, Attorney Osman. Let's start with a restatement for the purposes of our own benefit as well as the public. And the process and lean on the benefit of the esteemed benefit of our counsel to walk us through just the architecture of the waivers so that we know what it is we're talking about, and anyone who may be just logging on for the first time will hear it in sort of a sentient, organized way, even though many of us have heard it sort of evolving along the way. So Attorney Osman, Gareth, if you don't mind.
Yeah, sure. Right, so this is a 40B project, generally, as you know, this board sits as the board in place of every other board, and an applicant who complies with certain conditions in chapter 40B is entitled to waivers. Waivers fall somewhat between approval and conditions, but I think the idea with waivers is similar to that with conditions, for an approval, which is you don't want a waiver to, a denial of a waiver to render the project uneconomic. So you'll see a fair number of waivers that have to do with financial aspects. You'll see waivers that are done on a more specific basis, particularly in zoning where it is identifying certain dimensional requirements that the applicant can comply with. And then you're going to see some pretty broad brush waivers, like one that jumps to mind is stormwater. Applicants basically said, I don't want to comply with any of the stormwater ordinance, so I want to, I want a broad brush waiver against all of it. That said, in a lot of those cases, as you will see in some of the expert reports, the applicant is complying with aspects of those ordinances like stormwater. Just didn't want to get into the nitty-gritty of identifying what specifically the applicant might not comply with. So board's gonna have to address those product waivers, how it see fits.
All right,
And I'll say,
thank you,
Specific?
Congressman. The quick, before, Andy, if you can just scroll down on the waivers for a moment. For anyone, although I know it's only two, it appears, that are logged on remotely, for anyone in the room and all of us. We have, what's the total number of waivers? Can you scroll down to the?
There's 9 in total. I
Okay,
believe.
so- Up on the screen, anything that we're seeing is all part of the public record. There are 9 total waivers. They have multiple subparts. So anyone who might be looking to follow along.
So I believe it's actually 10. There might be a missing numbering in the last page, perhaps.
Okay.
At any rate, I believe it's 10 in total.
But this is posted, this is also.
It is, this is the most recent waivers list posted, was submitted by the applicant prior to last
On
year.
permits.gov.
there were two.
Yeah, exactly.
Okay.
It's just the numbering on the last page.
So thank you. For the record, everything that we're looking at right now is born of the most recent revision, as recently as even today. In terms of the distillation of waivers, which we numbered 10. But everything's on the permits.gov portal. So anything that we're seeing, the public sees, and is up on our screen in front of us. So, and thank you, Gareth, for the walkthrough.
Yep, sure.
Mr. Swanton.
I have something I'd like to say on waiver number 2. If you can scroll back to waiver number 2. It says. The applicant requests a waiver of 25% of the fees, which is for building permits and things. As they're applicable in affordable units. Andy, do you have some idea, is that like 25% of $100, of $1,000, of 10,000, of 100,000? I have no
Yeah.
sense of scale.
And I'm sorry, I thought, did we not push this out? I thought we sent this out to the board
We had
previously.
included the number in ballpark, I think it was 2 million.
Yeah, the total fee, we did include it with, I think, on a prior report to the board, but it was about $2 million, and so we're talking about like 1.75 roughly that would be paid here. I would say it's not an atypical request potentially,
No.
in the context of 40B.
No, I realize that, I just wanna, so it's 1 point,
Sorry, it's about $250,000 is what we're talking about in terms of order of magnitude.
so it's a $2 million fee, so it's 25% of it's about
Or
250,000.
sorry, 500,000, sorry, 500,000, sorry, I'm.
Yeah, that sounds about right.
500,
Yeah,
okay.
500,000,
Sorry.
requested waiver.
Thank you.
Mr. Chair,
Yes,
before we get to the waivers, I mean, I'm ready to get into that and also. Conditions, but. I mean, the first threshold question is whether the project's consistent with local needs.
Mhm.
We haven't actually, said
excellent.
that out loud, so.
Why don't we should articulate for the record what our conclusion and our findings are as a board, because those are, I think you're right, those are threshold inquiries that we have to find before we have the luxury of indulging in anything that follows.
Yeah, and there's a lot of wording that we're gonna have to wrestle with when we come back after.
Agreed.
Christmas and New Year's, but just big picture, I could go ahead and give, my.
Could you?
my bid just to get us going, or?
No, that's great. If you don't mind, if you wish to sort of state the proposal of our finding for the record, and then
Sure.
we can vet it with the board, the board en masse, and then.
Yeah.
Can I just make one clarification?
Yes.
Jerry, just so everybody knows, when you're gonna make your ultimate decision as to whether this is consistent with local needs, all your conditions are gonna be folded into that determination,
So
so.
is that something we should be doing at the end?
You can do a preliminary, like this is kind of where I am on it, but I think at the end.
Yeah, no, I
You're gonna
wasn't- I
want to
wasn't-
go back and look.
I wasn't intending that we would vote tonight, I just wanted to, lay out where I'm personally, where I'm headed, and hear from the other guys where they're headed. So, the 40B regs are pretty tortured, but the most useful sentence to me is consistency with local needs is the central issue in all comprehensive permit applications before the board. That's it, one sentence. So on that, I'm inclined to find that the project is on balance, consistent with local needs. And I want to explain my reasons why. There isn't a definition of local needs in the regs, but there is a definition of local concern. And it means protecting the health and safety of both the occupants of the project or the residents of the municipality, it's both. protect the natural environment, promote better site and building design in relation to the surroundings and regional, municipal and regional planning, or to preserve open spaces. So that's the lens we've been looking at, you know, we spent 5.5 months on it. And to me, I think the project gets there, you know, with conditions, in order to mitigate impacts in those areas like site and building design and all that stuff. So, I'll give my, you know, my thinking, the three biggest factors of why I think this project satisfies local needs. The first is city policy absolutely favors multifamily housing in place of this Kmart. That we didn't invent that, you know, that it's already in the 2017 master plan. That's not binding on us, but it's been in the public record for 8 years that there was a vision, at least by the previous administration, to transform Port Plaza into a mixed-use neighborhood. And then, you know, the current mayor signed a development agreement and in order to get the local initiative program going for this project, and so essentially he's a co-applicant. And that's why we've been calling it friendly 40B in shorthand. That doesn't bind us, I'm just telling you this policy from the mayor. The local legislature also last year, they put in a overlay district, which is not being used here. We'll make that clear in our findings. It's not being used, but it also would have allowed, but does allow multifamily housing here. The second reason why I think that in the big picture, the project serves local needs is that it's rental. It's all rental and 25% affordable. I know some people are, you know, have highlighted how that impacts the subsidized housing inventory, and I'll give you that, that's important, but from what we've seen in Newburyport, rental units, adding rental units actually can have an effect on keeping rental prices down, or at least not rising as fast. Compared to condos where we don't have any evidence of that. Every time a new condo comes on the market, the price just seems to go up. Rental is different. So that's very valuable, and I know it was noted by the mayor in the development agreement, and it's important to me too, for serving local needs, that it's a rental project. The third is the architecture, and that's what they're talking about in the regs as far as site and building design. And I do think this is appropriate for this location. There are different ways to get, you know, to box up a project like this, and you know, based on the work that we saw from them and the work that we've done with them. And I especially want to thank our peer reviewers. I thought the transportation peer reviewer and the stormwater peer reviewer were especially good and really pushing for the city. And we ended up, I think, with an appropriate design. That's my opinion. That said, I'd like to debate the individual waivers one by one, you know, make sure we're doing it carefully. We're not. There are some waivers that I don't think we need to give because I don't think even apply really. For example, the fee for the betterment fee. We have, of course, a legal opinion on that. And then there are conditions of approval that we really have to get into. And, you know, we're really down to, at least I'm down to one that the applicant doesn't like. So, and that's the left-hand turn lane, and we have to talk about that. Our consultant, I believe, has conceded, as I understand the testimony, that the left-hand turn lane is not necessary in order to mitigate harm to pedestrians necessary. The argument of our consultant was there is an existing warrant, you know, if you want to go by Mass DOT warrants for that left-hand turn lane. But the point is the project is actually exacerbating or worsening the condition for cars turning left. That's the 33% increase in left-hand turns in the peak hour. And so this board has to decide whether that's enough, that it needs to be mitigated. I mean, we need to talk about that. That's the one thing. Everything else, I did actually have a pretty severe concern about pedestrian safety in June, but we worked through that. And I do think the combination of the Hawk crossing with the advice of our consultant is adequate. Is it perfect? No. But I do think, personally, I think it's adequate. I don't think a flashing light, you know, the pedestrian activated light is enough. But a hawk light where all traffic must stop with a red will protect. And there's gonna be significantly new pedestrians here. We've all talked about that. And then going north, the key was to allow them to safely, residents of this project who don't live there today, but will with the project, to get to Story Avenue and to shops. And the applicant has addressed that. And so that's now incorporated in the drawings. Let's see. On the, there has been some, on other conditions, we have talked about the outflow pipe, but that's an existing condition. And our expert, Phil Christensen, has validated that flows will, from this particular project, will actually go down. They'll go down. So I don't see any, in fairness, how we could impose any condition about that outflow. I do think that's something for the city council to look at. You know, clearly, this has been going on for decades, and there are people that are especially benefited by that pipe, which is publicly owned, and they want to look at a betterment district for that. But I can't see imposing it here. And then, you know, as far as conditions of approval, I also, you know, there's been a lot of talk about how it's, you know, it's a 40B and we're limited on how we can do conditions of approval, but honestly, I don't, given the current case law, especially since last year, at the US Supreme Court, it's really all the same. It's whether it's fair. I mean, things have to be, it doesn't matter what project it is. When we impose whether it's a variance or a special permit or comprehensive permit, you know, there has to be an essential nexus to the project, has to really be a connection logically. And then what we impose has to be roughly proportional. I mean, that's it. If you just go by those rules, you're doing it right. And that's what we have to debate on that left-hand turn. And with that, I'll stop.
Very good. Thank you, Mr. Eigenman. Okay, where as a board do we wish to continue in that sort of line of deliberation and thinking? And again, that's a great sort of opener.
Well, I guess, I mean, I'd like to know if anyone wants to vote no, and that would be a good start.
Okay, we can do a soft poll of the board. Is there any member of the ZBA, having heard from Mr. Eigenman with respect to the threshold inquiry of that finding, which is fairly critical to all that might follow? Anyone find themselves inclined to vote no?
No, I'm not inclined to vote no or to vote yes yet. I agree with Mr. Eigenman. I mean, as a general proposition, certainly a development that for moderate income housing or affordable housing in the city is certainly consistent with local needs, or that doesn't end the inquiry. We have to satisfy ourselves that every applicable regulation and any request for a waiver needs two tests. One, it is consistent with local needs, keeping in mind our obligation under state law to encourage and promote affordable housing, and two, it must be protective of health, safety, and welfare. So I don't believe it is as simple as painting with such a broad brush. I believe that it is warranted, in this case, to go through every waiver, every dimensional request, and conclude that those are, one, consistent with our obligation to encourage affordable housing, and two, protective of health and health, welfare, and the environment. Now, I think we all know, as a matter of, after debating this for many hours now, that there are probably one or at most two issues that really are going to deter us. But I don't think we should necessarily make that leap so quickly. And I further understand that there is a development agreement here, and in many respects, that has addressed some of the concerns in a positive way that the city desires, and that is, you know, there's an obligation here to keep some percentage of these, available to the Newburyport residents, I think 70%. Two, there's an obligation to maintain these as rentals for 35 years under the development agreement. All of those are positive and requirements that we as the zoning board could not impose because we don't have that authority. The city and the administration has negotiated those terms, which are on balance, in my view, very positive. However, I still believe that we have the obligation to be a little more granular in our assessment of the waivers that are being asked, the size, scale of this structure, how it relates, all of the factors and considerations that we would consider with any large structure of this case. So, am I prepared to vote yes or no? No, I'm not. But that's kind of how I see it.
I appreciate that, Mr. Bennett. I think that it's premature for any of us to sort of aspire to do any of that, but this is sort of the unpacking of the deliberation, which is really just the outing of our thinking for purposes of the
Right.
process. So I appreciate
Yeah.
those comments. I honestly, I share most of them. Mr. Swanton.
Yeah, in general, I've learned a lot about 40B here. I guess I'm the only non-lawyer in the group here. Better, of course.
Lucky you.
You could probably pass the bar on you.
Yeah.
I realize a lot of the populace in town would like to simply say it's too big, but I've learned, I don't think that's an option. I'm actually pretty close to where Jared is, I'm with a couple of things, I do think on balance, it's consistent with local needs. For the reasons he stated. My big issue is the left turn lane. As he stated.
Hawk versus signal versus.
Well, no, the hawk is by the boards here, we're doing a hawk, but the question is, do we also add a left turn lane? Their consultant says, well, that's a convenience. Our consultant says it's a matter of safety. I know 2.5 years ago, somebody was hit and died that night in this location. And I just want to make sure it's safe. And I'm not a traffic engineer, but when our consultant says it's a matter of safety, that really kind of hits me. In addition to the 33% more cars in an area that already warrants a left turn lane, I do worry about bicycles too. We're adding 400 pedestrians or some big number in these 212 units, and there'll be a lot more bikes. And we've heard the people who live there, and I've seen it myself, people waiting to take a left and other cars streaming around them, and we're about a bike getting run over. So I just wanted to add those couple things. On the outflow pipe, I also agree with what he said. I was impressed that our consultant felt that not only early view, and this is my early view.
Thank you, Mr. Swanton. Mr. Blat.
Yeah, I would agree with, I think, the general sentiment in the room here that, there's definitely a big thing that is, left to tackle here. And, maybe a medium-sized thing or a small thing. And then as we proceed through the waivers, there may be some other things that jump out at us, but I think that's generally where we are.
Maybe, and I agree, perhaps, Mr. Chair, maybe we should really make a decision on the most the thorniest issue before us, and that is the traffic issue on Low Street and how we want to deal with that is, because I think that.
So just dive into the elephant in the room.
Kind of, I'm suggesting that if that makes sense, I think everybody is kind of, we've all,
I can do it either way. I mean, either we can go through the waivers one by one, which is perfectly reasonable tonight, or start with a condition. Doesn't matter to me, whatever you guys want.
Let me ask this question, and I appreciate the sentiment and sentiments of my colleagues. We're feeling our way through a bit, right? And we have limited visibility in this sort of feeling our way through endeavor, but what do we aspire to get done, if anything, tonight? You know, so if we were to sort of think about this in terms of compartmentalizing the additive momentum forward, what do we wish to
I
get through tonight, and what is get through
Yeah,
tonight?
I think we get through talking through both the waivers and the left-hand turn lane or any other conditions the guys wanna talk about. But the goal before we finish and go off for the holidays is so that staff and Garrett know enough to draft all the language. So when we come back in January, we have proposed language that we can then pick apart and vote on.
I agree. I think, and forgive the, self-indulgent metaphor, right? But if we were thinking of ourselves as artists, we are not ready to put like brush to canvas. We are talking about mixing paints. Like, let's figure out how to mix up the colors we need to actually set cadence for the discussions we need to have, and empower the experts that surround us to help guide us in what has to follow after the holidays. I think there's a tremendous amount of lift here for all of us, any of us and every of us, but at the end of the day, we gotta start somewhere. So this is the most cumbersome part, which is, grappling the first rung and then climbing. So if we were to just start tonight by just unpacking in discussion and deliberation, those two sort of sentinel elements, and just see where that discussion takes us, it'll set a framework for Attorney Orsmond and those that counsel us to sort of help us frame condition language that we can then toil with when we come back after the holiday. Is that what I'm hearing? I mean, I don't mean to sort of,
That's what you're hearing.
I don't mean to be like turning letters in this exercise, but I feel like we gotta start somewhere. And yeah, please.
So when I'm writing regulations sometimes or things like this, just remind people, sometimes you can ask for like alternative conditions or findings
Okay.
if you're not ready to make the final decision, and you just ask us to draft it A or B, and you can choose, later if you're there. So don't forget that is always a possibility, and if you're just not ready to make a decision yet, just go ahead and do that. And then sometimes you look at something on a piece of paper, I mean, it changes how you view it.
I appreciate that. We appreciate that. All right, let's jump in. Let's start with, I think that's a great approach. Anybody have any alternative view on that approach? Because in the absence of that, I think that's what we do. Let's start discussing in no particular order those two sort of fundamental pillars, which are the conditions. In any order that we may wish to sort of delve into priority of them, and the threshold findings that I think Jared had walked us through. So let's unpack that, and this is basically just an open discussion. And I think as we open discuss, we will sort of refine what we need to really hone in on. This is the most awkward part of this process, I think, but it will hopefully get better quickly. Jared, do you wanna
start on the conditions of approval or the?
let's start on the conditions of.
Okay, yeah, so, and looking at this question of the left-hand turn lane, the first thing is, we should always be consistent. So it's not just because the 40B regulations say.
Can I interrupt just for
Yeah.
1 second?
Yeah.
Andy, could you put up the graphic with the left-hand turn lane while we're talking about this, so we?
It's in front of this October 28th.
Yep.
Sorry, Jared.
No, that's okay. So, I mean, the first thing I want to say is that, I don't know that this board's ever reviewed a 212 unit apartment building before, probably not. So they haven't, it's not like we have a precedent, we said, oh, we had a 100% market rate project and we also, required left-hand turn lane. But I don't think that's necessary. The point is that our zoning code already says all kinds of stuff about if you get a special permit, which we're gonna waive. And if you go through site plan review, which we're gonna waive. The applicant has to maximize the quote, convenience and safety of vehicular, bicycle and pedestrian movement. And then, as far as the regs, the 40B regs, and then some of the land court cases, we're on solid ground. It's not, this is kind of fundamental. We don't want to create a situation where a project is worsening something. And we haven't asked them to mitigate. Doesn't matter what project it is. So, that's where I'm coming from. And, I really, because I'm leaning heavily on our consultant, Kevin, because he was very meticulous, I found. A lot of his suggestions were taken to heart by the applicant and little by little changes were made but he's been consistent on this left-hand turn lane. So in my mind, I feel like I can't overrule him in this case. I don't think I know better. I find it persuasive that, yes, there is an expense. And I'm not trying to add undue expense. And I also recognize that it's not like there's no problem today. This is an exacerbation of an existing problem because there are already cars turning left. But thinking of other projects over the years I've worked on, if you make something, you often have to, it goes over a tipping point and your client, the developer has to pay for the roof. So the order of magnitude, now they're not required to show us their pro forma until they object to a cost. So I didn't expect to see it. I'm not complaining. But we don't actually know their total cost and all that stuff. But I am cognizant that the widening, there doesn't have to be any taking of land. Because the right of way, this is an old county highway. I don't know how the city ended up with it, by the way, but it used to belong to Essex County. So I'm kind of curious.
The dissolution of county government.
Yeah, but it's not automatic. I don't think the city council ever took it, but anyway. So be it. The right of way is already huge, so we don't have to worry about that, but it's cost. It's moving curbs and restriping and paving. I understand that. But I do think, playing it through, you're supposed to think ahead of how the Housing Appeals Committee would look at it. And I don't think it's just a matter of mere convenience, although in their cases, they poo-poo mere convenience when it's a denial or not denying. But still, I do think it's a safety issue. Again, I believe what I heard from our consultant was that it's a vehicular safety issue rather than, but he didn't address bicycles. I think Ken raises a good point. It is absolutely, I think it's substantial evidence based on my own experience living here. The way people pass in the right hand and we report on roads where we're not supposed to. I mean, it's just notorious. We'd be dreaming if we didn't take that into account. And there are different ways you can deal with it. You can put in bollards, but I don't think that's gonna work from what I heard from Kevin. And so that's my thought, is I am inclined to impose that condition. And I realize it adds to the pro forma cost of the project. That's not my desire. The good news is it doesn't appear to require any consultation with Mass DOT. I know the applicant was very concerned about that. For example, if we were to require a signal, which we're not, it would require getting probably a highway access permit, indirect highway access permit, and then that adds a lot of time and cost and complication. And I don't believe the left-hand turn does that. So what we're down to is something like $700,000 in estimated curb and pavement and stuff. And again, the justification, personally, sitting here tonight, we're not voting tonight, but currently I think it's justified. But not just justified, I think it's necessary. I think I would regret, what I don't want to have is a regret once this thing is built. And everyone points, because people are going to complain about this project no matter what, I know that. But I don't wanna regret if there's a dangerous situation created by the new residents that are trying to just get home in their car. That's where I'm at.
I just want to make one small comment. Your chair. You mentioned 700,000, the sheet that we were given by Vanessa
Yeah.
said that. That's the Hawk is 180, but the Hawk with the left turn is 720, so that difference is 560. So
Point taken, I apologize.
Okay.
So it's a delta of $500,000.
Right.
You're right.
So, yeah. Okay, continuation of that thought line. Thank you, Mr. Eigenman. And Mr. Swanton. Mr. Bennett.
I just have I agree. I think for me, it gets down to, I mean, our decision at the end of the day has to be driven by record evidence. So what we have here are two expert witnesses who have made highly professional presentations. Certainly, it is within the discretion of this board to believe one expert witness over the other. I tend to believe our expert on this point for the same reasons that Mr. Igerman. It certainly there will be an exacerbation of vehicular traffic. And although the record is devoid of any specifics, or there haven't been any analytical analyses undertaken, it seems to me that we can take administrative notice that a 230 unit apartment complex, which has a storage facility for bicycles in the basement, will increase both pedestrian traffic and bicycle traffic. So I take the point that from both of our experts that the situation warrants a left turn lane at the moment, and that is not as a consequence of the development. But I think that in balancing the community's need for adopting conditions which are consistent with the community's health, safety, and welfare, with our obligation to adhere to our obligation to encourage and support affordable housing. Based upon the evidence in this record, I'm convinced that the record supports a decision to include the left-hand turn lane. So for that reason, I agree with Mr. Igerman. And would vote good to adopt that as a condition.
Mr. Delat.
Yeah, I think I would point out in the record, I think that we heard testimony on September 30th from Mr. Dirk, the applicant's expert, where he indicated that the contribution of the project locus right now to vehicle trips, pedestrian trips, transit trips is zero, because there is no activity on the project site. So whatever will be an exacerbation of what is now. So I think that is evidence that is in our record. And that sort of, I think, militates in favor of the views of my colleagues.
Yeah, just to pile on here, I've always felt the left turn lane was critical. I like the way Jared described it. I noticed Garrett's note talked about if it's something to protect the safety of the occupants, that's something to hang your hat on there. And that word safety is right there. And Garrett sent us. I feel so strongly about this. I know we can't push the project to where it's uneconomic. So I don't know what it costs to build a building.
Keep in mind, that's not a bright line. That's.
No, I understand, but I was just thinking out loud here. It's, I asked my AI app today how much it costs to build a 212 unit apartment building in Newburyport.
Never do.
And it came back, you know what it came back and said? Oh, you mean Port Plaza?
Did it really?
It did.
See what I came back and said, are you talking about Massachusetts or Texas?
Yeah.
I mean, they had all the plants, it was shocking, like, it's just shock, I'm impressed with what AI does the other day, but anyway. It's a big number, 100 million or some number.
Yes.
So if we impose a $560,000 cost on a project that costs 100 million, does that make it economic? I don't know. But I feel so strongly about this. That, and I'm just one person speaking here. I would go so far as to pay for some of it by, instead of waiving 25% of the building fee, of the $2 million building fee, waive 30% of it. Throw 100,000 on the table. I mean, I know that's a radical thought, but my understanding is we have the ability to do that, and we need to have that left turn lane. I don't want to see somebody hurt there as a result of this, having gone through all these months here, and I would go so far as to entertain helping to pay for it.
Heard loud and clear. Thoughts? Anyone, other members? Mr. Swanton is suggesting the idea that,
I just threw it out.
no, but we're all just, I mean, this is part of this process, which is, let's unpack it all, you know, like, let's put it all on the table and see what is rational, what's reasonable, and what's, you know, sort of like wildly sort of outside of that paradigm, if at all, but I don't
I'm
know.
talking about 5%, which would be about 100K,
Right.
just to try to show some good faith here that we're trying to solve a problem together.
To be the devil's advocate for a moment, and I'll just opine, it's just one voting member. It has to come from somewhere, so that would be, you know, is it incumbent upon us to make sure that we know that we have the capacity to not just say it in the offer, but we don't wanna create an unfunded mandate.
Well, I would certainly want to know from our
Well-
attorney whether or not we have the ability to do that.
Well, I mean, you're talking about funding something with the public
Yeah.
fisc here. I don't know if we wanna
Yeah.
get into that at this moment. I mean,
No, but I think we're just talking out loud at this point, and I respect that as well. It's way too early to get into the granular sort of balance sheeting of that kind of a proposal.
Well, if I could, I mean, I can,
Please.
to respond to your thinking out loud. So in the regs, what the hack is gonna look at on an appeal is the aggregate of all the conditions.
That's right.
So, you know, the fact is we're considering, I mean, they already have it's not really a condition of approval because they already have a contract with the city on the betterment fee. But our attorney tells us that they're getting a break on the betterment fee because of the operation of time. That was his advice. It's not because it was any special dispensation, but you know, that's one thing to think about. The other is they have asked for a waiver of 25% of the building permit fees. So I think that's where you should be thinking of this is the aggregate of all the conditions. But I think what will not be reliable is expecting the city council to appropriate any money. I don't think that's a reasonable.
I agree with that.
I don't want to propose something that's not within our ability to propose.
Yeah,
I just
no,
thought.
I'm just saying that,
Maybe it is,
yeah.
I don't know, I just
I just don't think it's gonna, you know, given the realities of how these things work, I don't think that's gonna go anywhere.
I mean, clarifying your math, your 25% waiver is $500,000.
Yeah,
The difference here is $560,000.
right.
I think we should rise and fall in the merits of our balance sheet without having to rely on the balance sheet outside of this room and this table. You know, and I say that in so far as, are there tradables? You know, are there balancing of equities that we can control? With respect to waivers that, you know, are specific to this ecosystem because to do that, what you suggested, Mr. Swanton, to Mr. Argument's point is that we have to, you know, even if we were to say it and to speak it and make it so, city council has to ratify it. And if they don't, it undermines.
City council, I thought this, I'm confused.
If we were talking about trying to appropriating money to.
I'm not talking about appropriating money, I'm talking about.
You talked about us paying, like
No,
paying for.
no.
I apologize.
I'm talking about rather than give them a 25% waiver on the building fee, make it 30.
Got it.
Only if we can do it. I'm
So-
not
so
proposing.
That's, then
taking
you and I are.
someone else's authority away here.
Absolutely, you and I then are aligned in our thinking, I'm thinking about if we're to wheel and deal, as they say, or sort of like trade and balance, we should do it within our own balance sheet, so to speak.
If no one else wants to do it, I get it, I'll withdraw it, I'm just.
No,
Yeah, that's how strongly I feel about
No, no, I don't-
Nothing should be
I don't
withdrawn.
think what you're saying, I don't think what you're saying is crazy. Again, the hack regulations, sorry, the 40B regulations say you have to think like the hack does. That's what it says. Okay.
Yeah.
So we're thinking like the hack, but
And they're not gonna lie that.
But Gareth will also, pointed out early on, way back in June. The way that their regs are written on these conditions is a bit confusing because it says two things. It says. Conditions in the aggregate cannot make the project uneconomic. And that's what we've been talking about.
Right.
But it also says. Are the conditions consistent with local needs? We talked about that. That's the, danger and so on. And it says a condition which makes a project uneconomic will not be removed or modified if, as a result of such action, the project would not be consistent with local needs. So it's actually not the end, even if it does make their rate of return, the regs suggest that there can be an overriding, concern. And it's really hard for us to do all that math. I mean, as Rob is saying, we haven't seen a program, we just have what we have.
Right.
So I don't know that we're gonna be able to get down to that. I hear you, I wanna be efficient, I don't know that we're gonna be able to do it.
Not tonight, we won't, but
Yeah.
I think we can begin to unpack topically these areas for
Yeah.
discussion. I wanna give Attorney Gareth an opportunity to address what we've talked about so far, just so that we stay guardrailed.
No, I mean, I think to answer Ken's question, yes, the board has the authority to. Like waive more of, say, a building permit fee than the applicant has requested, so if that's the direction the board goes in, I'm not worried about that. Being an unlawful practice, but I'd also say you can think outside of the box a little bit and you can say. Like, if you're not at a point where you're willing to say, we don't think this makes project economic, if we impose it without some offset. You can do things like, and this one goes back to what I'm talking about, alternative conditions. It's like, put it out there for the mayor's office to fund some portion of it. And if the mayor declines, then you can take it out of the building, permit fees, if you want to do that kind of stuff. So, you might want to start mulling that over and make your decision.
Oh, thank you for that. And
Just a couple of good thoughts or considerations, just having seen plenty of city council meetings and budgetary discussions and so forth, and my client agree with member argument that. I think it's, to me, it was even advisable sort of going at, I think as Stephen mentioned, just sort of making presumptions about what essentially, whether it's directly or indirectly, will be later discussions and expectations of the city council, mayor and so forth about the city's budget. And so forth, even though this is properly before it was a request, I would, caution against maybe modifying that to go further and making presumptions that others will sort of adapt to that, financial, because the city council does look on a yearly basis at, on the operating budget, looking at the building permit fees and coming in, right? The other thing too, as I just mentioned, in terms of timeline, to where Gareth was just, suggesting the possibility, just wanted to note that the actual time frame in which the mayor could even the mayor or the city council could sort of mobilize and appropriate funds, especially given the end of the year, going into new council session, given the time frame for your making a decision. I also don't know that timeline wise, that would, be feasible to achieve or even have that sort of exchange, if you will, just as a practical matter. So I don't know whether you'd be able to get something like that in hand, a definitive answer from, mayor and city council about filling some sort of gap there in order to inform your process, so to speak. I just wanted to point out that it's not like we need to get an answer on that in a week through one office. You'd have to wait for a city council process as well, I think. But obviously that.
I'd like to take my suggestion off the table so we don't derail the discussion. Let's continue with the rest of the discussion.
thank you, Ken, and not that
It's fine.
Not that I don't think that, I think that that's very appropriate for us to discuss, but it might be a cart before the horse at the moment, but, with that in mind, continuation in the discussion, Jeremy.
Yeah, well, so there are I wanna talk about all the other conditions. A lot of them are general conditions, just for any project of this size. I just wanted to air them out. And then, let staff over the holidays write them up if you guys agree, but I'll get to them. So one of them is, you know, we don't have any authority under the subdivision act, I would sort of leave the sub, so I assume. You know, we probably need to condition the approval on their proposed A&R plan. So that everyone knows, yeah, this is the plan we saw. But whether they go and get an A&R at the planning board, I don't think we have the power to do that for them. I think they have to do it.
I am,
Wait a minute,
first of all. Wait. Please, I've seen zoning boards of appeals signing our plans in the 40B context, so.
Yeah.
You do add, sometimes, you know, the applicant may actually want to see if the planning board would do it first, but it's more normal.
But isn't that, I mean, I'm happy to do it because I mean, if, you know, fine, if we have the power, but. I don't understand how we can when it's under the mass general law. The rules for an A&R, it's not just the local rules of the planning board, how can we do that?
I understand, but like,
You've seen it done.
I've seen it done and you.
Fair enough. I guess what I'm saying is, let me get to the point. I don't have a problem with their proposed A&R plan. I don't, because we're gonna condition it, as we've said many times, on seeing the reciprocal easement agreement. So it's okay. I'm all right with their lot lines, personally.
Right, add to that, Chair.
please.
Just what we, Jared had referenced there, what Garrett got, my read of it, I guess, is that I think the actual ability to do so, I think is because it's coming from the statute, I think is what Jared maybe is getting at, is I think that maybe is perhaps probably before the planning board, generally speaking. Certainly, I think in the case of concepts of 40Bs, you can see that other CBAs might have endorsed those. It would seem reasonable to me, you know, without necessarily creating an undue process to just say, you know, the A&R plan is essentially approved for the purpose of the planning board to endorse that, you know, just leave that statutory authority there. Might seem more regular, so to speak, in the context of the statute, because the permitting process and the regulations essentially is being waived, but the endorsement maybe is still falling statutorily to the planning board. So maybe that's, to me, that seems like a reasonable way of dealing with this versus say, we will endorse the plan here. I don't have the objection one way or the other per se, but it might be reasonable to also say, you know, we accept this to the degree that the planning board is now expected to endorse this A&R.
Yeah, we sit as a ZBA, we sit in loco planning.
Except that the statute is granted, I guess what Jared is maybe referring to is the fact that the regulations are local, but the statutory authorization for the planning to endorse.
I
It goes to
understand.
the planning board, I guess, is.
Wait, the statute, hold on, can I just?
Please, I wanna hear, please, I wanna hear, and with respect to Mr. Porter, I just wanna hear Attorney Horseman.
So, I mean, do you think that you could endorse a subdivision plan
Under 40B
under 40B as a ZBA?
as a comprehensive
No.
permit granting authority?
No, I think we can waive subdivision,
Right.
we can waive it. But I thought the
I agree with that.
subdivision general law doesn't talk about the zoning board, it talks about.
It does, but the board, whether that, you can't like. You can't waive state laws, I get that.
Yeah.
But you have two statutes that tell you different things, right?
Yeah.
You have 40B, which says you act in place of all local boards, right? And then you're looking back at the subdivision law, which says the planning board does, that's whether it's an A&R, whether it's a subdivision plan, so you have two acts, I mean, and I can look at the law, but generally when you have like two acts, the more specific that.
Well,
Governs
look,
more.
I guess it's really at the applicant's risk, it's fine, it just seems to me weird, I mean, could we grant a variance from the state wetland statute?
No,
Right, so only what our conservation commission can.
They can, right?
So that I'm giving you the counter example of what you're telling me. So you're saying in practice. 40B doesn't allow you to waive state law on wetlands. And then, but we can for subdivision, it's fine, I don't care, I'm saying, I already said, I like
But
I like
there
the
are
A&R.
significant differences.
Yeah, and the other thing is, again, it's an A&R, approval not required, meaning the planning board just has to sign it. They can't say no.
Right.
So all I was getting at is I was just trying to be precise on, you know, when I'm doing something I'm allowed to do. If you say we're allowed to do it, fine. I'm not gonna find it.
In my opinion, you're allowed to do it,
Okay,
if the applicant would prefer to give the planning board.
fine,
Yeah,
up to
to
you,
do it,
okay,
sometimes that looks more regular and they prefer that, but.
Okay.
if-
because we're not giving any wetlands, you know, statutory, okay.
we look less like a rogue CBA usurping authority wherever we can grasp it.
Yeah, we're just gonna do whatever we
The,
want.
the primary difference between wetlands and subdivision is like subdivision is a delegation statute. So yes, the planning board does the ultimate authority, but they also get to adopt the rules and regulations, you know, and those are local rules and regulations. And that's why, you know, an applicant can, request waivers from local rules and regulations that the planning board adopted. Wetlands protection law, only DEP gets to do the regulations. There's no delegation there at all. So, but you can't waive that as a local.
But there, well, I'm not gonna argue this anymore. The point is, the condition of approval I have in mind is their A&R plan, I'm fine with personally. But I do think we should have a condition, and we have, as we said, we have to see the reciprocal easement agreement. And we have to give direction to our legal counsel on what the reciprocal easement agreement has to say. But you'll tell us who has to sign the A&R plan. I don't really care, it's fine. So for example, there need to be easements for users of the project to pass and repass over the Port Plaza Shopping Plaza by cars, bicycle and foot. There have to be permanent rights for the users of the project, for the life of the project to park in those areas. That has to be in there. There have to be a right to install above ground or underground utility lines as shown on the project plans, because some of them are off-site next door in so-called Lot B. They have to be temporary rights so they can do the construction. So, I mean, those are just the four obvious ones that I know. Along Low Street, the whole fringe of the project site, we have to have a condition written up about protecting the trees. We talked about that. But also, we have an ordinance about the sidewalk. So I think we need to specify, the 6 foot width and cross-reference our ordinance on fixing the sidewalk. And that's the kind of thing that we, from that experience, we probably need to require a bond. Right? Or some surety. And then we, although it'll be shown on the drawings, I think you also, a good practice would be to state the details of the hawk signal and the handicap ramps and the turn lane, if that's what we want to do. You gotta write it out. You can't just say, see the drawings. That's not safe. If you want them to do repaving, you gotta say that, if it's repaving within all of the work area, so on and so forth. Those are kind of standard for any big project, but let's not forget them. Our consultant had asked that, again, we're not requiring a traffic signal, but he did talk about putting up the arms, and the conduit. So that if there is a project in future that triggers the requirement, I think it would be across the street, right at the ice cream place, right? But I think you also need to have a reimbursement agreement to reimburse this developer. So they don't get a free ride. You don't want the next developer getting a free ride on what the previous developer did. That's not fair. And we can, there are forms of that we can work on. So again, this is all a what if. We would require just the conduit, because while they're digging up the street, they might as well put in a conduit, put up the arms. And I'm getting that from Kevin Andre. I'm making that up. And then, but I'm also adding, you probably want to do a reimbursement agreement in case that Haji's goes forward or something else nearby, they need to pay their fair share. I don't think we've ever wrestled to the ground the center median island. Whether it's, I think we did want to put it in, but it's not necessarily shown, and so if you want that, you gotta say so. This is the median in Low Street. Yeah, the refuge, yeah. Because I think that's the wrong drawing. I don't think that's the hawk, with the left, I don't think that's.
This is the hawk with the left,
Is
yeah,
it?
yeah. The other drawing, I have that as well from the most recent
Okay,
submission.
all right, whatever, I'm moving on. We have to have help from our consultant on writing the condition of approval about. You can enter the garage from the center, but you cannot exit going southbound from the, he needs to help us on that, so it's enforceable and real. They've already agreed to it, but it needs to be written up. And that, exiting is supposed to be, if you wanna go on the Low Street, it's supposed to be from the easterly driveway. He mentioned in one of his reports over the summer, and I can find it if you need, is the wayfinding inside the garage, written notices. So it's not just by lore, it has to be posted. They already put in a curb also, which is really helpful, so that people are discouraged. Transportation demand management measures. We have various measures that the planning board, I'm sure, has imposed, but. This is a much bigger project than we've had in a while. The state of the art, whether it's Everett, Boston, Cambridge, wherever, is different. You have to, usually you have to inform residents, especially because they're renters, how they can use MIVA. And again, we don't need to reinvent the wheel. There are other standards out there. If you guys want them. I think we do, because we're being asked to waive the parking. Instead of doing over 300 parking spaces, we're doing 200, which is consistent with what we had for smart growth districts. But there is no train station here. So you may want to be fed up with transportation demand management measures, which are, again, totally normal for developers to see, write them in. And then, so they have, the people that are managing the apartment building have a script that they work from. They get a new tenant, they say, here's how you can take the bus or ride your bike and all that stuff. And then you can make them strong, weak, whatever you want. I talked about the trees. Our consultant talked about a contribution. And again, you have to have $75,000 to a study for complete streets on Low Street. I'm not personally hung up on that, because I'm looking at the big picture of, the left-hand turn lane and the building permit fees and all that. And I don't know when that study is gonna be done, but I wanted to flag it for everyone because you did raise it. You wanna have a condition about maintaining the landscape areas, even the ones on private property. Because oftentimes, if the project changes hands decades from now, they just let everything die. You want to be able to go in and say, hey, you got to replace all the plants. And then there were stormwater conditions that Phil gave us. He wrote them in his report. We need to write them down and copy them in. I mean, just an example, he called out an oil water separator as, such and such location. He was very thorough, location design of floor drains inside the garage, those details, you need to write them in. Or when they go to get their building permit, it won't happen. Screening and buffering, really only have one side to worry about, and that's the easterly side. There is a resident, and he came, I think, to our very first meeting, and he said, well, probably anything's better than a Kmart loading dock, he admitted. But it's actually off-site, because the boundary line under the A&R is gonna gerrymander so that that's gonna be lot B. But if you're expecting there's vegetation there now, I believe, I don't know, and I don't know, because it's not shown on this drawing, whether any of it is controlled by the developer, but I think we should drill down on that. I mean, just to nip in the bud future unhappiness about buffering. The applicant said that they would meet the specialized energy code, so we need to write that in. You should do that. And I think it's municipal code section 5-65.4, which we'll talk about when we talk about the waivers too. And then you guys have to decide what's pretty common in Massachusetts now is that you don't require a building to be LEED certified because that's expensive and unnecessary. But you do expect them to be LEED certifiable, meaning they use the checklist that's published by the US Green Building Council. And our resiliency committee did write us a letter about that, I'm pretty sure. So again, you're not saying, oh, you have to be LEED platinum and get one of those plaques. But you have to follow the checklist for whatever level you guys want to set. And there's a standard specific to this kind of product for residential multifamily. You all, just like as if it were a subdivision, which it isn't, you wanna write in specifically that they're responsible for trash and recycling. Yeah, I can tell you from bad experience on the city council, it comes back to haunt you later if you don't. It's just that future residents will say, we don't wanna pay for our trash anymore, and they lobby their city councilor to do it, so just, and this came up on the Evergreen too. So, subdivision, so we should be proactive on that one. I alluded to it before, in a project of this scale, you need some kind of performance guarantee. It's unlikely, I mean, they're totally incentivized not to leave a big hole in the ground. Because the same people own the shopping center. And the tenants in the shopping center will go crazy if they just leave an open pit. But to be responsible for a project of this size, you know, a couple acres, we should have a condition on that with a performance guarantee. So that if something happens, there's litigation between the general contractor and the developer, that the city isn't left with a hole in the ground. This happens all the time in Boston and San Francisco. It's a disaster. The petitioner agreed to do full cutoff night sky fixtures, and they submitted a photometric plan. You should make it a condition of approval, just so there's no argument later. There it is. On the signs, it looks like there are 4 signs. I was having trouble. It's too stupid to see them before, but looks like there's a marquee sign, a blade sign, and 2 monument signs. And to the degree that there's some specification now, you should say what they are. So that there isn't an argument later, oh, we actually want 6 signs, you know, or. You know, we want a sign that's twice the size of the marquee shown in sheet XYZ. It's better for everybody. They can always come back and get a variance, you know, because they probably will, because 3 years from now, their signage plans may change. And then also, it's not something we usually do, but finally, I think you need a construction management plan. So when it's a project this big, there's temporary impacts on the neighborhood, and again, they're incentivized to do this on their own because they also own the shopping center, but again, we would be stupid and lazy not to ask them for a plan, and usually the general contractor doesn't. The general contractor says, here's where all the contractors are gonna park, here's how I'm gonna control dust. You know, this is when I'm gonna haul things. And again, you don't need to reinvent the wheel. Almost every city in town that's done a project like this in Massachusetts has a requirement like that. You can copy and paste it. And it's better for everyone because predictability, and it's written into, you're required to be incorporated in the general contractor's contract and with the subs too. So it gets pushed off on them. So that's the universe of conditions that I think, you know, staff would need to work on. That's my list. And I wanted to hear what you guys.
I'd like to add one.
Yes, please.
Oh, you didn't mention design, and I asked Attorney Mead last week. Are you gonna build it as the plan say? I think the answer was yes, of course, but I think that should be a condition. That all that good work that has been done to look at the design and the brick and all the different suggestions were made, I think should also be referenced in our document.
Yeah, that makes sense. I mean, for example, they showed us a materials sample. And if the board feels that, you know, that's a material, sorry for the pun, that's a material condition of the approval, you should say so.
Well, I mean, Gamble went on his way to say, you know, for a building of this size, they did a good job. He started right out with that, and then he added some things like more brick in places and stuff that I think they liked, and it made it better. I just want to make sure it's built as.
No, I totally agree.
Very simple.
I agree with you. I mean, for example, I'm the one that asked their architect to show me examples from other projects he did. And one of the reasons I did that, he used different materials in those. So for example, think of down on in Norfolk County, he had a project like Cohasset or something, and it was all wood paneling and sort of, you know, faux fishing village. I don't want that.
Right,
I think what we bargained for, what the city bargained for was brick.
right,
We should say so.
right. Anyway, that's, I mean, I thought he had a pretty good list. I realize what we're trying to do right now is give things to the planning department and to our attorney to write up. we're not making final decisions, but
No.
I think you had a good list of things to write up. I just want to add design.
Yeah, I think that would fall into like the planting schedule and, all the sheet.
I think it's an important point because, when people get cute with stuff and, construction or site plans are one thing, but when you have like renderings out there and you really want someone to comply with renderings, you really need to be clear that that's your expectation, or otherwise people will just say, oh, that's just an illustration of what we're gonna do, right? And that's your concern.
That's my concern. I mean, they raised the heights of the front of the building, so you
Yeah,
didn't
yeah.
see the air compressor, the condensers up top. I mean,
So I mean, if
I
that's.
just wanna
something
see them
that-
follow through, that's all.
If that's something that's important to the board, then we have to articulate that, and we have to include it in the.
Yeah, and they said they would, so I don't think it's a big deal, right? So.
No, but this is the threshold exercise of just establishing the, the margins, the outward boundaries of our discussion, our deliberations, and will ultimately be our conditions. Even if they seem obvious, and certainly with the assent and collaboration of the applicant, it's okay to say it out loud. And appreciate it. Continuation on that thought line, and Jared, thank you for taking the lead on that, and certainly, Ken for dovetailing on that. That's great momentum forward in terms of giving our planning department and our legal counsel the opportunity to help us fine tune this, what will be the subsequent written document for us to consider. Mr. Bennett, was there anything I wanted to add?
No, not to that list. That was,
Okay,
more than comprehensive.
okay.
And I suspect that our
Yeah.
learned counsel will have even more in his standard, terms and conditions, which will apply to this.
Very
So,
agreed. Mr. Delisle, anything?
I have nothing further.
Okay, so I think that with respect to unpacking, in the first instance, our conditions, we've made some headway, to say the least, and sort of outed a lot of our concerns and our sort of terminus thinking on how this should look. Do we want to migrate our deliberations now to sort of the second tier of what we hope to get done tonight, which is dealing with the waivers? And going specifically into, now that we've dealt with conditions, let's topically verticalize the waivers as they're presented, as they're requested, and we can unpack them.
Yeah, and well, Garrett and Andy, have we given, have we given you enough to work with for the conditions to draft?
Yeah, I think it's very helpful. Yeah.
Okay,
Great.
all right, then you wanna get into the waivers?
Yeah, I'll say, sorry.
We'll talk about a schedule, but I think it'll be important when we do the deliberations that we have a draft of the decision in front of you and you have time to review it. And we could kind of
Then we can fine tune.
review
Yeah, it becomes a wonderful chopping block of deliberation and content and context. Unless there's any objection among my colleagues from the ZBA, will press pause on that, pending the further refinement by the planning department and our council, and move into a similar analogous discussion on waiver requests. Who wishes to lead that?
Well, I'll go first again, just get it out of the way. Sure. So I took them in the same order generally that they're presented in the request. Look, on the subdivision, I guess we're empowered to sign the A&R plan, and if we do that, I guess there's questions whether we have to waive the standards. That's up for Garrett. Obviously, we didn't apply the standard, we applied our own standards, so I didn't, but the standards are for the planning board, so you figure out how many angels fit on the head of the pin, Garrett, I'm not gonna stay out of it.
I mean, I just want to be, I'd have to look at what's been done. I can't say that the board can endorse it,
Yeah,
so to speak, under the statute. But one way or another, the board can sign something that says, that stops the planning board from saying, I'm not gonna do anything.
yeah, I mean,
That's
they
the
have to
point.
sign, but, and the point is, we didn't apply, there's no argument, we did not apply the subdivision control rules and regulations, and I'm not saying that we should.
Wait, are there I mean, this isn't a subdivision.
No.
So we don't have to worry about one at all.
What about
Are there
site plan
more
review?
specific
What about site plan
regulations
review?
regarding?
Wait, that's later.
Well, that's later. This is
Okay.
just a subdivision. So in other words, you know,
Subdivision.
I mean, if it's not a subdivision, by definition, the only section that applies of the regs, the local regs is for A and R.
Sorry, if I could just, given that the purpose of the subdivision control law, all of the regs that extend out of it in the NR process is really just to make sure there's essentially safe access to the lots that are being developed. I'm just wondering here, again, if you're memorializing the decision, approving the plan as depicted with the, understood ANR plan, will you defer that endorsement to the planning board versus, how's that here? Put that aside for a moment, but, given that the frontage essentially the safe access, as you can see in the plans is being, is being provided there effectively, at the end of the day from Low Street. And to some degree for the fire department, others from, even up from Story Avenue, for instance. You could sort of, again, memorializing it all together, just reference the fact that the access that's needed is essentially referenced in those plans, including the driveway accesses that you're maintaining, access easements for through, from Story Avenue, for instance, here. That addresses both frontage, length, and physical access on Low Street, but also perhaps importantly to the fire department, other folks too, getting there from the other
Yeah,
locations.
but Andy, that's not a waiver. We're not waiving it. That's all an A and R requires. That's my
I
point.
think my answer, you don't need to waive subdivision rules and regulations, they don't apply. If there are local regulations, like some towns have, and I don't know if Newbury has this, they'll have like a page or two of regulations on A and R plans.
They have a paragraph.
Okay, maybe there's something in there that needs to be waived.
Nothing more
Because there's an
than
A&R.
It's like 3 sentences.
Right, right.
I mean, so if you tell us that we're approving the A and R, we'll just go through those
Yeah.
3 sentences.
Yeah, I would.
We don't have to waive anything because they don't apply. Subdivision, the other 50 pages of the regs just don't apply.
Agreed.
Okay. On the building fee, yeah, I mean, Ken already raised a good point. Like, first of all, how much? But also I had a slightly different question. Is just, practically, I mean, there's no way Greg Earls is gonna process the building permit for this building by himself. There's just no way. So there is going to be a cost to the city. Now, by law, we're never supposed to charge more than the actual, what it really costs us to do it. But I guess I'd like to know, and that's why I tried to ask Greg before, but wasn't aware of the waiver. He came in person couple months ago. Like, what's it gonna cost him to farm this out? Cause he's not gonna do it in-house. I don't wanna take a bath on the building permits, but I also don't wanna, it's normal. I gather, Garrett, to ask for a waiver like this for the affordable units.
Yeah,
But I don't really know what I'm waiving, because I don't know what practically, we don't have it, this isn't Boston, we don't have a huge ISD. I don't know how he's gonna pay to review their
but
plan.
it's normal, and if you look at housing appeals court decisions, when they issue their own permits, they usually have this like 25% rule. It's become a practice.
Okay,
But just like everything else, it just depends on the economics and, there's no like, I guess the theory behind it is generally when people are building. These types of projects, you lose money, they lose money on building.
oh yeah, no, I totally
That's why
understand,
they-
it's a subsidy, I got it. But, we also have to balance, we've got our left-hand turn lane issue,
Yeah,
and we have, and they got zoning review too, part of the. And I do this too, in my practice, I can give you more affordable units if you give me more total units, that's how I cross subsidize. And we're giving them 212 units. So there needs to be some work done there, I'm not saying no, personally, I need more information.
Well, one question I have, and maybe we can dig this out of the record quickly if we can. I mean, might we have a nexus between affordable rents and market rents? I don't know if the difference is 25%, but if it's 10%, then maybe that's a bit much hard for the discounter. I'm just throwing that out as a way to Jerry's point of having some. What's 25%? Where does it come from?
Yeah.
Does it have to be grounded? Should it be grounded in some sense of rational, thought? So I don't know. Andy, could you, if you look quickly, what's, for example, what's the market rental and subsidized rental for a unit in the application?
I'm sorry, I don't have that right.
Did they give us,
sorry.
did
It's in- yeah, yeah.
they give us the, I'd have to look, see if we can.
Yeah, that's like-
It's just some.
We can figure out what the.
Yeah, there's a chart.
There's a chart.
Chart in one of the early
Yeah,
files.
I'm not saying it's the correct approach, but at least it might give us.
It's more data.
It's just another data.
More helpful data.
Right, that's,
So the data he's looking for is, what's the difference between the revenue that you get, what's the drop off? And what I'm looking for is, I just want to understand from Greg, how is he really gonna process this application? I just don't, he can't do it. What's it really,
I would like to know specifically, if it's gonna cost them more than $1.5 million to farm this out, whatever the work that's involved here. I don't wanna lose money on it,
yeah, exactly.
but that's a big number, so
The good news with Greg, of course, is he does have a revolving fund. He doesn't have to go back to the city council, but I think we would be stupid not to sort of ask.
does he know where to get the answer, given that this is the biggest building ever built in Newburyport?
Yeah.
Do you know what I
Well,
mean?
you can
On
ballpark.
larger projects, they do farm it out, so to speak. There's, consultants who end up assisting them with bigger projects. It's obviously the biggest one, or, bigger one, that falls in that category.
Could somebody check and let us know?
We'll follow the building commissioner tomorrow, but I, obviously don't have any more here now.
Thank you.
I have another observation. I don't know if I want to resuscitate Ken's initial thought, but it's quite easy to write a condition which would say the first $50,000 of affordable unit fees are waived, and then it's X% discount thereafter. That's not a challenge to draft such a provision. And it's not difficult to apply either, if we want to go down that road. But I'm not trying to breathe life into your thought.
No, what I'm hearing is this is customary, so it's like, okay, I backed off of it.
Okay.
If typically, if you have 25% affordable, that's what you do. And that's what I'm hearing.
It's common, I wouldn't say it's like, we talk about what's smart, what's smart, I have no idea.
Well, in your experience,
But my experience is very common to see this.
what's the number that you've seen?
You see 25% because they correlate it directly to the number of
Oh,
affordable
okay.
units they're providing.
So if they're just.
I don't have a problem with 20, right, for the record, I don't have a problem with the 25%, and I accept that it's normal, and it's not something crazy to ask for. It's really the peculiarities of Newburyport's tiny building department and massive. Okay, moving on. Now I know the applicant wants belt and suspenders, so they wanted sort of a blanket waiver from anything in chapter 5 of our ordinance, which is the whole buildings and building regulations. And I'm really not trying to be difficult, because I know why they want to do that. They don't want to discover later, as council said, that for applicant, oh, we forgot to get a certain permit, and I get that. The problem is, I don't feel that we should have to go through chapter 5 and make sure we're not, giving something away. For example, buried in chapter 5 is our rental to condo conversion ordinance from the 1980s, which of course is never enforced. But I would waive that, no way. So that's why I'm saying, if there's something specific in chapter 5, for example, the earth removal article, I would give that. So later on, it was called out. It's Article 7, Roman numeral 7 of chapter 5, earth removal, where, I would grant that waiver. This is a problem we discovered over on High Street near where I live, where there is no soil removal board in Newburyport. So there's no harm in waiving. But I don't want to give a blanket waiver to chapter 5, because I don't know what I'm waiving. Personally.
I don't even know what it is.
Stormwater management, I think this one is real easy, where we don't have to waive the standards, because they're actually meeting them. What we're waiving is any requirement that they get a stormwater management permit. So normally, they have to get a stormwater management permit from DPS. We can waive that, and that's it. That's all we have to do. And then the standards don't even apply. I don't want to get into I don't want to have to, I don't think it's necessary, unless Garrett tells me otherwise, for us to go through every single one of the rules and regulations of stormwater and say, they're meeting this one, they're not meeting this one, because we're just saying, you don't need a permit from DPS, you're done. I already talked about earth removal. Dimensional, yeah, and this is where I think Greg was saying, we need to go through one by one to be meticulous about specific waivers. So dimensional. They're asking for, let's see, 1, 2, 3, 4, 5, 6, 7, 8 dimensional. Personally, I think they're all appropriate. First one is minimum lot area. We're allowing a lot area of 115,000 square feet instead of 852. It's fine. Second, the front yard setback is gonna be 2.2 feet, not 20 feet. Yep, I'm okay with that. The required side yard setback at the easterly line is not 10 feet, it's 0. Why is it 0? Because lot B that they own is to the east of it. It's not the neighbor, not the residential neighbor. It's a truck lane. Minimum setback 20 feet. No, we're gonna do 0. Again, why? Because it's them. It's the shopping center. Maximum building height, and this is where I think Greg wants to be super careful. The zoning says, the base zoning says 35 feet. They've asked for 55. I feel that satisfies local needs. 55 is appropriate. That, you know, with the parapet and the screening of the mechanicals, I would vote in favor of that waiver personally. Building coverage is normally capped at 40%. We're gonna allow 61.3. Again, given the situation, I'm okay with that. Minimum side yard. Now, there are 2 that relate to the remainder parcel. So when they create the new parcel, as counsel for the applicant explained, we should note in our decision that it's not putting them in violation for the remaining parcel. And the 2 there are, as I understand it, minimum side yard setback at the easterly lot line, 29.9 feet instead of 40 feet, and then a rear setback of 0.9 feet instead of 40 feet. Again, because it's a shopping center, you gotta make it all add up. The next waiver has to do with parking. Because this is, you know, we're trying to encourage mixed use development, the city, when I say we, by policy. And I personally believe it's consistent with local needs. And this is akin to the chapter 40R development. Although there is no train station, there's only bus service. I do feel it's appropriate in a situation to grant a waiver of instead of 319 spaces for 212 units to 261. And then we can talk about, and then be specific about the visitor parking and all that, but I would be prepared to grant that waiver. Personally. On the signs, I already talked about that. I would grant the waiver. They don't have to get a sign permit to the extent that they have 4 signs as I described. They don't need to go get a sign permit. It's a waste of time. And then, we don't have to site plan review. We just have to waive that it doesn't apply. I mean, we just have to say it doesn't apply. We don't have to go through, I believe, all of the standards one by one, because we can just say we're waiving site plan review. We just spent 5.5 months doing something like site plan review. I don't want to do it again.
Can I just interrupt for a sec? I assume when something like, he's making an assumption, I assume Gareth will look at best practice in Massachusetts as far as 40Bs and let us know if that assumption is correct.
I don't want to interrupt.
I don't want to rush, but I'm just basically counting on you. He mostly works in California and other places. I'm counting on you, or tell us
I
Massachusetts.
definitely agree with what he's saying.
All right,
Like,
good. Thank
you want to minimize, the one other thing I could say is sometimes, and you gotta be careful with it. But sometimes when people ask for broad waivers, you can create some kind of language like to the, it's waived to the extent obviously inconsistent with the plans, right? So you're not granting like this huge waiver that they're not even thinking about, but you are saying, look, where they've specifically proposed something on a set of plans, to the extent that's inconsistent with one of our provisions, we're waiving that provision. That's it. But you have to be very careful about that because you don't want to go so far.
Sorry to interject.
The last one I had is they had alluded to the Port Plaza overlay district, which is 13 months old now, but that's under the option of the applicant, whether that even applies, and they didn't apply under it. So I don't think it's appropriate for us to grant a waiver because it's just not relevant. But if in order to protect the record, you want us to say, we hereby clarify that this didn't come in with a Peapod, I would do that. Didn't. That's it for waivers. The other waivers, I wouldn't wanna give, because I don't think they apply, we already talked about. The waiver of the request for the sewer equipment, and that's appropriate. For reasons we already discussed months ago. And then I don't understand what we'd be waiving on the conservation, because my understanding is that. They don't need any relief at this point, what they're asking for is some sort of. Something that may have changed in between they went to the Conservation Commission and came to us, and I don't know what that is. And I don't have the expertise.
I'm not aware of anything that would be an issue here based on the commission meeting and review this.
Streets in the buffer zone.
Right.
So it's a little bit similar to what you're saying, it's like, so there's the state, which probably nobody want to waive that, right? And then, you know, usually there's also a permit requirement under the local act, so some of that like stormwater, we just want to say. We don't want to have to get the permit under the local wetlands protection ordinance.
Yeah, but
That's all.
I know counsel for the applicant cannot speak, and so that
Right,
you will work this out offline, but.
Yeah.
Andy is saying.
The commission issued a determination of applicability in this case, issuing a negative determination of applicability with a few findings and so forth. Recognizing and making it clear in their decision that they understood the rest of the stormwater review for engineering and calculations and whatnot would be finished under the ZBA's process here. So that's how, they did not take it as a notice of intent. Of work with the buffer zone, but rather a lower grade sort of negative determination of applicability, negative impact, you know, no adverse impact essentially. Based on what's being proposed here to the wetlands, provided the stormwater review.
it's a local decision, if it's a negative determination that applies to. Under the local bylaws, so I'm gonna take a look at it and see how.
Yeah.
We'll propose
Yeah.
something in the decision.
Okay, yeah, I just wanna know exactly. What are we doing that would be any different from the conservation, because to this point, until I saw that language, I didn't think we were doing anything. That they were complying with everything and it was a non-issue. Just wanna know, what specifically, again, they can't speak now, you guys figure it out and get it back. That's it, that's all I have.
Yeah. Human service to the board here for going through that, essentially people. I just like to comment on a couple things. One, I agree on the notion of the kind of the blanket waiver for chapter 5. It's somewhat troublesome to me, so I agree with Mr. Evans on that. My only other observation is that at the hearings, you know, there was much discussion regarding the size of this project. And I think it's important for us, no matter where we come out, to kind of talk about it and how and to what extent we have any jurisdiction over that. So, yeah, I start with the proposition. I mean, we have, the mayor has, and the city has signed up on a development agreement, which builds a 200 and some unit apartment complex here. So, and as I mentioned earlier, there are positives in that development agreement. And I'm supposing that there have been pretty serious negotiations regarding size and the number of affordable units, and all of that went with it. So that is one of the considerations we have to recognize and just. Secondly, we have broad requests for waivers of virtually every dimensional control. Now, historically, you know, the zoning board uses those as surrogates for controlling size, scale, and massing, height, setbacks. We all know them. We all deal with them every other week here. So that's certainly, and these are pretty significant requests for waivers. Third, I note that our expert on the question of size and density was foursquare supportive of a development of this size, and he felt as a matter of of importance in development of the city that the map, certainly the numbers of units and hence the scale of massing which follows is good for the city. And fourth, we certainly have a need for both affordable and so that cuts in favor of the size. And then finally, we're faced with the regulation, which says that if we're going to apply a regulation such as the height limitation, we have to find that it is consistent with our obligation to encourage affordable housing and also demonstrate that it's consistent with public health and safety. So I guess my final observation is that we're not drawing on a clean sheet of paper here. There's a plaza there already. I suspect that undeveloped parcel, and this was the first structure that would be built. It might be different in size and design and scale and a whole bunch of other things. Unfortunately, we don't have a tabula rasa here. Stuck with a development of that port plaza. And the question then in my mind gets down to all those factors coming into play. Can I support these dimensional waivers, particularly height and lot coverage, setback and the like, which are, in my view, quite significant and a significant ask. But in balancing the need for public and affordable housing, the fact that this is a friendly 40B and that our own design engineer and architect supported the size and scale of the projects with significant improvements, which the applicant has agreed to. For those reasons, I'm comfortable with the dimensional waivers. With respect to the other ones, Mr. Eigenman has knocked them out of the box, and I have nothing else to add.
Very good. Thank you, Mr. Benny.
Can I ask a question?
Please.
With respect to the waivers under 8, the site plan review, all those waivers A through, what is it, A through J, are those waivers, that we're going to grant subject to them not being inconsistent with something else that we've, that we're going to condition? Or how, it seems like we're just kind of like giving short shrift. As Mr. Igerman said, because we've been talking about these for, months now.
I agree with the approach that Jared suggested, just for this general matter, and seeing the site plan review process, how many details are covered in that section. And the amount of sort of unpacking you'd have to do to me, it makes more sense to just say no site plan review, is required by the planning board in as much as the plans are proposed, here. And leave it at that. I guess I need to defer to Gareth, obviously, but to me, that seems like the simple.
Oh, so we're just saying no site plan review is required.
Right, as opposed to walking through.
Got it, okay,
The ordinance and all the findings and all the, details running through every one individually, that would be, it's unnecessary to me, on the spec, doesn't really benefit anybody.
Right, but that also then allows for a situation where we're not allowing a waiver, which would be inconsistent with something that we're requiring in another.
Yeah,
Okay.
yeah, I think it's better for that.
Yeah, yeah.
I agree, I like that approach,
Okay.
I understand why the applicant did this, but I don't think we need to go through each site plan review criteria. And say, we're waiving this, we're waiving that, we're waiving site plan review, period.
Got it.
It's kind of, and then, our conditions are, and some of the applicant's changes are all. Reflective of the kind of things you do in site plan review, so that's part of the decision as well.
Understood.
Yeah, I agree with that approach as well.
Do you have anything else?
I don't.
Mr. Swanton.
Yeah, on my comments on the list is, I kind of agree, chapter 5 to me is a bit of a mystery. I didn't understand enough what's in it. Well, I need to do a little research and I'm looking forward to see what the planning department comes up with as far as the details within chapter 5 that are important for us to waive, so that to me is a mystery one. When it comes to local planning board regs and local wetlands regs, I have served on both those boards in other municipalities. I don't mind if we could waive those things. So I'm a little more lenient there because that's the whole point of a 40B, waive those things. And I'm not aware of any issues in either of those places, so I'm more lenient there. Mr. Bennett's conversation around, the dimensional waivers, but this project has some public benefits in terms of apartments and affordable units. Brings up a question in my mind where this fits in. I mean, how long do those 212 units have to stay rental as opposed to be turned into condos? And how long do these 25% affordables have to stay affordable? Is that written down anywhere? Is that a condition? Is that, I think that's in the development agreement.
Development agreement has.
I actually, let me call upon Attorney Orstman to address that, because there is an answer to it.
There's a couple actually. One, the subdivision, the subsidizing agency here, he's kind of signing off on the deed restriction, and most often those are in perpetuity. There's also case law that says, as long as you're not complying with local zoning and you need the benefit of your 40B comprehensive permit, you need to provide the affordable housing, right? So it's not like someone can put this in and say, I'm restricting units for 40 years and it doesn't comply with zoning in 40 years, it would never be approved 40 years later, and then they don't have to, carry on that obligation. So there's case law on that. So those two things are getting.
But what is the duration? Is it perpetuity? Is it
It's
gonna be 15 years? What is it?
Well, to one of your questions, development agreement requires the units to be maintained as rental units for 35 years.
Okay. It is.
That's in the development.
The answer to that, I'm just dealing with the
Yeah.
affordability restriction.
Right.
The answer to the rental, the condo, that is something the development agreement can speak to. Otherwise, there's a process the applicant has to go through, which is to apply for what would be a major modification of the company of the permit to change from rental to condominiums. They can't just do it. Right?
Yeah.
So they gotta come back.
That would come back before us.
They gotta come back before you, and they've gotta get the blessing of the subdivision.
Before the special permanent granting authority?
Yes.
Yeah, they've gotta change the comprehensive permit
For which one? For the duration, for the 35 years?
for going from rental to condo,
We're going from rental to,
condominium.
okay, how about the 25% of the units that have to be affordable?
It's a perpetuity in the development agreement.
Those are perpetuity?
Yeah.
Okay, I just don't know. Is that part of what we write down when we write our decision?
We can, yeah, and I would, if belt and suspenders, I suggest.
I would
do
encourage
it,
us,
but
I would encourage us to write them down, because that's the public benefit here.
it's gonna be it's gonna be in the agreement. I mean, in the
Okay, thank you.
Yeah, Ken, that's what I was citing as one of my big three for.
Yeah.
Is that it's rental.
So I'd like to see it written down, how long it's rental.
Right, I want it required, because that's what we bargained for.
If you just want to memorialize what's in the development agreement, essentially, it's the 35 years is for the conversion. And, the 25% of the units is being affordable is in perpetuity.
Well, do we wanna give them give them the right to convert automatically after 35 years? I don't think so.
Yeah, sorry, just to clarify, that's from the development agreement terms, so.
that's what the development, I'm not sure you can write it all you want. You can put a condition that says it's gonna be, rental forever. The applicant still has the right under 40B to come back and request a modification of the permit to say, I want to go from rental to condos, and has to go through that process. So I don't think it's material what you put it, you can put it in there, but it doesn't take away the statutory rights of into.
What do people typically do? What do municipalities typically require on this point?
They act on the application that's before them, which is for rent. That's all they're improving. They're approving, right now, all you're approving is a rental project.
Okay,
If
thank you.
they want to do something else, they gotta come back.
Okay, thank you.
Can I ask you a question?
Sure.
Is the zoning board of appeals bound by the provisions in the development agreement between the city and the developer?
No way.
Okay,
It even says in the agreement that we're not bound.
okay.
Says so.
And you couldn't enforce the development agreement yourself. Right, that's the city, right? So it's a separate,
Well,
it's a separate agreement, separate.
well, I guess, yes, yeah, it's a little, it's kind of a nuance here.
It's-
I don't know, we could impose conditions which are inconsistent with the conditions of the development agreement. For example, the one we just identified, 35 years, we say, it's 4 years, I'm just
The development agreement does not bind the
preclude us
board in
from
any way.
imposing conditions which could be inconsistent with the development agreement. Okay, thank you.
You're not party to the development agreement, that's simple. You're not one of the parties.
Yeah.
I've done the math, I think we closed the hearing on December 9th. Is it really Saturday, January 17th, we need to be done by? Does anybody else count around 40 days?
Unless it's extended. Yes,
Yep,
We can't extend it,
no,
no, not by ourselves.
so Saturday, the 17th, okay.
Well, we're gonna meet before then, and they'll have everything written up.
we got everything written up the week before then. Yeah, no, we.
Yeah, one of the things we were gonna discuss tonight is the date that you're continuing to, so we might want, maybe want to touch on that now in part, but. We had talked about the 12th and the 14th, right, so as possible dates for that.
Anything further?
Thank you, Jared.
Yeah. Okay, is there, so for purposes of this evening, we have unpacked both the conditions, the contemplated conditions, given guidance and some guardrails to, with the benefit of, and for purposes of best effort drafting to our council as well as the planning office. And we've also gone through the requested waivers with the same goal in mind. Is there anything that any member wishes to add to or qualify or open a conversation around with respect to either of those two, we'll call them big silos or subject matter verticals on what we hope to get done this evening before we kind of proceed? Okay. With that, I propose that well, let me ask, does the board want to continue at this point and give the planning office and our council the opportunity to start to put those together for purposes of our revisitation after the holidays to conclude our hearing this evening, having completed those two big verticals? Is there anything else that we have to deal
Well, I
with?
think when we figure out when we're gonna meet next, we should give staff and our attorney a deadline to submit us the written materials in
Okay,
advance. If
Of
we show
course.
up at the hearing and we're looking at the documents for the first time, that's not gonna.
no, I agree with that. Why don't we do that now? So why don't we talk about that now and then we can undertake a motion to continue with those specifics in mind and then part company for the holidays with that, you know, with the plan to reconvene with from the office to review in advance once hearing. So when I guess if everyone's in with the calendars, when do we want to try to meet?
What are the dates?
You can toss out the 12th, which is a Monday, and the 14th, which is a Wednesday, as being potential dates that don't have any conflicts and have room availability and whatnot.
I'm available both those days.
The 14th is 2 days before the deadline. I mean, is that kind of close?
I agree, Monday the 12th, and can we do Monday the 12th?
Monday the 12th works for me.
So it gives us some time.
Do you want to reserve the 14th in case you have discussion on?
I was just thinking the same
And then
thing.
you want us to come
Yeah.
back with revisions based on.
Yeah,
that?
absolutely,
Yeah,
Seems like we
absolutely.
should have
Them both.
one iteration.
Yes.
Yeah, let's
Good idea.
book them both.
Okay,
But
So-
that means we need the documents probably, you know, the week before.
Yeah.
So you're gonna come back from New Year's and it'll
Lucky
be
you.
due like that week.
You do it this week, you do it this week.
let's do it tonight.
It's Monday, no, I'm talking about these.
Well, I mean,
So-
they can get it in early, that's up to them, but.
My inclination is to think that the fifth is maybe a little early, but sometime that week certainly, I think is, I don't know, Garen, it's partly it.
Well,
I think you're gonna get probably a 25 page. This is it. How much time do you need to review it? And all
Yeah.
that? I think it's really before you have your dinner.
let's call it, let's schedule the 12th and the 14th.
But get us the documents no later than the 9th. So we
Okay.
can read-
Oh, yeah, I totally agree with that. I was thinking perhaps early that week. I just don't know what.
Well, you guys
Fifth
want it,
would be-
I don't wanna presume that you worked over the weekend, so what do you guys wanna do? You can make it earlier, you can make it Thursday, the 8th,
We shoot for the 7th.
Wednesday, the
Seventh.
7th.
Yeah.
That's enough breathing time.
I think that's reasonable.
Let's do that.
Yeah.
It's lucky 7, Wednesday, the 7th.
I would just say that, I mean, the heart and soul would be the conditions, so I mean, we may wanna focus on those and
Absolutely.
the stuff you're gonna hang
Like I
up.
said, I mean, some of these issues that are unresolved, we can draft a couple different.
Yeah.
Options and you can check the box and then we'll include that in the final decision.
Okay. All right, so with that,
For the purposes of tonight, have we adequately deliberated with respect to the other subject matter verticals?
well, I mean, we've, I think what we've done is we've set the parameters of proposed conditions and the parameters of proposed deliberation. Talking points, discussion points in terms of the waiver requests.
Sure.
Our job next will be to take that in as drafted, review it, then discuss it, and then refine it. Qualify it, delete it, amend it, reject or accept it.
But
So,
but if there's anything, if there's something you wanna get out on the table.
Yeah, really.
now's the time.
Oh, yeah, I mean, I didn't have anything in particular, but I just wanted
No,
to share.
I think that when we part company this evening, it will be with the presumption that we've talked out loud to those big, columns of subject matter. If there's something else that you wanna sort of unpack, now would be the time, because we're asking council, and we're asking planning to prepare the first draft of this sort of synthesized.
I don't think we, Steve and I were commiserating here. I think we need as a condition also, all of the improvements and changes made in the design based upon the dialogue between our expert and the applicant's architectural team. And, that's not a lot of guidance, Andrew, but I think it's all pretty well embodied in exhibits that were submitted.
Yeah, we can take a look
So-
against the
in the last
most recent
one,
plan
yeah.
sets will show most of that, but we can check against the prior exchanges just to make sure it's
That's
accurate.
the elevations,
Yeah.
that's the perspectives.
Yeah.
Yeah, I mean,
It's also customary to have like a final plan of review. I mean, the idea is like, I think these plans are actually quite far in advance, but the idea of 40B is they're supposed to be somewhat, still earlier in the stages and then, you get your final review, but it's gotta be consistent with the decision parameters. It's not, I'm saying, you get final review, but it's not an opportunity to revisit, the waivers or decisions or the material, things like that. It's just to make sure it's consistent with your
You
decision.
see this again?
Or is that with the planning on?
No, that's gonna be that's
Yeah.
probably gonna be the building inspector.
Okay.
So, all right. Yeah, you're not, we're not reopening a hearing and we're out.
Yeah, if I can make one comment on your point, I think on these verticals, I think we basically said on design and stormwater. We have no big issues,
Yeah,
and it's really the one issue on parking, I mean.
or traffic.
Traffic, yes.
but there were some modifications that the experts kind of sorted out and agreed.
No,
to those.
I agree. I mean, what I was trying to say is, rather than just say, per the proposed plans dated XYZ, if there are things that are especially important to us, for
Right.
example, pedestrian connection, it's shown on the plan going up to Low Street from the donut shop, but we should call it out. We should. It's
Yeah.
better for everyone, so that, years from now, staff knows that that's a material
Right.
condition.
In reference to our architects, exhibits that he introduced. Just,
Very good. All right,
Well, then I move to continue, the deliberations on this matter to January 12th.
Second,
Great, thank you, Mr. Eigenman, seconded by Mr. Swanton, on the continuation of this hearing till, January twelfth.
I'm hearing,
I'm sorry, deliberation, till January twelfth. Calling the roll, Mr. Swanton,
yes.
Mr. Delisle.
Yes.
Mr. Bennett.
Yes.
Mr. Eigenman.
Yes.
And I vote yes, that's 5 in the affirmative, the ayes have it, the motion carries, matter is continued. Thank you all, very much, and, we'll see you after the holidays, everyone.
Do you wanna?
Got minutes to approve.
Yes, we'll do that, we're, now that's closed, we have the minutes from our last hearing. Any comments or changes to Gretchen's minutes from our last 40B hearing where we closed the public hearing?
No.
We have a motion to approve the minutes.
So moved.
Motion's made and seconded, and this is a voice vote, all those in favor say aye.
Aye.
Any opposed, no votes, abstentions, the ayes have it, motion carries. Thank you, Gretchen. Do we have a motion to adjourn?
Thanks.
And seconded. Motion's made and seconded, and a voice vote, all those in favor say aye. Aye. No abstentions or no votes, the ayes have it, motion carries, meeting is adjourned. May, have a good evening and a good holiday. Thank you.